Good day, everyone. Welcome to Property Law. I will discuss today is all about action publiciana. So let's start. There are three kinds of actions available to recover possession of property. So first is action interdictal, second is action publiciana, and action third, lastly is the action reivindicatoria. So I'll discuss is action publiciana. So action publiciana is the plenary action to recover the right of possession, which should be brought in the proper regional trial court when this possession has lasted for more than 1 year. So it is an ordinary civil proceeding to determine the better right of the possession of real independently of title. In other words, if at that time of filing of the complaint, more than 1 year had elapsed since defendant had turned plaintiff out of possession or defendant's possession had become illegal, the action will be not one of the forcible entry or illegal detainer, but an action publiciana. On other hand, action reivindicatoria is an action to recover the ownership also brought in the proper regional trial court in an ordinary civil proceeding. Hello everyone. I will talk about JR number 218269, June 6, 2018 case. So this is all about application for land registration. Supremati Domo petitioner versus Republic of the Philippines. So facts are petitioner Supremati Domo filed an application for registration of two parcels of land covered by with a total area of 1,273 square meter. Domo alleged that the lots belonged to her mother and that she and her siblings inherited them upon their mother's death. She further alleged that through a deed of partition with absolute sale, she acquired the subject lots from her siblings. Domo traces her title from her mother, Trinidad, who purchased the lots from Florencio Mabalay in August 1951. Mabalay was Domo's maternal grandfather. Mabalay, on the other hand, purchased the properties from Carlos Calica, the heirs of Marcelino Ispenas, opposed Domo's application for land registration on the grounds that the properties sought to be registered by Domo are involved in the action reivindicatoria case. So issues are whether or not Domo is able to prove that the subject property forms part of the alienable and disposable land of public domain. Second is whether or not the requirement that documents to prove the status of land shall be based on the land classification approved by the DENR Secretary is not a mere superfluity. So the rulings are first, no, Domo failed to submit any of the documents required to prove that the land she seeks to register is alienable and disposable land of the public domain. The applicant bears the burden of proving the status of the land. In this connection, the court held that there are two documents which shall be and must be presented. So first is a copy of the original classification approved by the Secretary of the DENR and certified as true. Second is a certificate of land classification status issued by the CENRO or the PENRO based on the land classification approved by the DENR Secretary. Second is, yes, the requirement that documents to prove the status of land shall be based on the land classification approved by the DENR is not a mere superfluity. This requirement stems from the fact that the alienable and disposable classification of agricultural land may be made by the President or DENR Secretary. So, wherefore, premises considered the appeal is partly granted and the assailed joint decision issued by the court a quo is hereby modified in that the complaint for action revindicatoria filed by plaintiffs' appellees is dismissed for lack of cause of action.